Welcome to week 3 of evidence law. Week 3 is going to be slightly different than the last 2 weeks in that it's going to be broken up between myself and Salim. I'll be starting by talking about relevance. So just to catch you up, just to contextualize this, first couple weeks we talked a little bit about proof, the ultimate place that we're going to get to, that we're trying to get to, why evidence matters, because it helps you prove your case on the basis of some standard of proof. David talked a little bit last week about talked a lot about it, about the rules surrounding adducing evidence. These are, as he mentioned, the somewhat technical and procedural rules, but the proper form that evidence should be in. Now that we've covered that, and we'll touch on that a little bit here when it comes to section 58, actually. But once we're confident that we have adduced evidence properly, that doesn't mean it's going to be admissible. The whole question that will arise about the admissibility of evidence, and to determine that, the first question really is it relevant? Is it relevant evidence? And once we've established that or not, then we can turn to the possible exclusionary rules. Then towards the end of the case, towards the end of the class, talk more about instructions that the jury is given in some circumstances, touching again on proof. But now we're in this question right here, relevance, and then Salim will talk about one exclusionary rule, which is the one to do with hearsay. So I think there's two reasons, there's many reasons, but two that I'll talk about for why it's important to understand relevance. One, and this is just a quote from one of the recommended readings from last week, the reading from Justice Gagler, in which he says that relevance is the basic rule of admissibility. It is the first question you have to ask. And as we'll see, that comes directly from section 56, which sets up a presumption that evidence that is relevant is prima facie admissible, thus shifting the burden to the other party on the balance of probabilities, pursuant to section 142 sub 1, to demonstrate that it's not admissible on the basis of some exclusionary rule or discretion. The other main reason, and this is going to flow, I think, pretty well into the second half of this week's lectures, is that relevance helps us determine the application of other rules. I think hearsay is probably the clearest example of that. Because the party who is adducing the evidence has the burden of explaining how it's relevant. It may be the case that they will have to say that it's relevant for some purpose that triggers another rule. So as I said, the clearest example of this is hearsay. You might have to say, oh, this is relevant to prove the truth of this matter. And if the form of that is it's secondhand evidence, it's evidence of an out-of-court statement, then it sounds like you might be dealing with the hearsay rule. So give this to us, my friend Salim, to deal with. So let's start with the text of the act. Section 56, as I just said, this is going slightly out of order. Section 56 explains the stakes, why it matters if evidence is relevant or not, and it matters pursuant to subsection 1, that except as otherwise provided by the act, evidence that is relevant is admissible, which is great for you if you're trying to admit evidence. On the other side of the coin, evidence that is not relevant is not admissible. Okay, what does relevant mean? How do we prove that? How do we demonstrate that? The rule, as we talked a little bit about in the first week, seems to be a pretty low standard. It admits a broad ambit of evidence. And it contains language that is, we're going to find, is quite similar to the definition of probative value with a few key differences. The evidence that is relevant to the proceeding is evidence that, if it were accepted, could rationally affect directly or indirectly, so directly or perhaps circumstantially, the assessment of the probability of the existence of a fact and issue. So here we are assuming that the finder of fact will accept this evidence, and simply that it could rationally affect the probability of the existence of a fact and issue. The word, as we'll talk about in the tutorials, the word rationally there might be doing some work. It's unclear exactly what that means. It might just be a word that the drafters throw in there, or it might actually mean something. But overall, it just seems to be that that if accepted, if the fact finder accepts it, it bears some logical relation to some fact and issue. Section 57 deals with what is called provisional relevance. We won't go into this in too much detail, but it seems to deal, or it does deal with a situation in which the relevance of one piece of evidence depends on the admission of other evidence, the admissibility of other evidence. So we can say that evidence is provisionally relevant until that other matter is determined. So perhaps we can't admit evidence, or we can't say right now that evidence of the accused being at the cafe next to the bank robbery is relevant until we can demonstrate that a bank robbery did in fact occur. Maybe that is a fact and issue. As for Section 58, you might recall that David discussed this last week, and this is a provision that allows for inferences as to relevance, which was interpreted in the Air New Zealand case. This provision allows the trial judge to make an inference as to the authenticity or identity of a document, therefore suggesting that, contrary to the common law, authenticating a document is no longer a requirement during the process of adducing that evidence. It's an issue that goes to the weight of the evidence, the probative value of the evidence for the fact finder. Now, before we get on to the cases, I think it's useful to draw a distinction, because you'll see this in some of your reading, that there is a distinction between what I think is a test of logical relevance in Section 55 and the concept of legal relevance. Partially because the wording is kind of confusing, because you would think that Section 55 is the law, and its test of relevance would be therefore a test of legal relevance. It's not quite the case, though. There's this concept that exists out there in some of the common law of this notion of legal relevance. You can see that in the Law Reform Commission report, which in its section that's going over other tests of relevance and why they decided to not go with those other tests. And one of those is that there should be some threshold degree of probative value. That relevant evidence is evidence that has some degree of probative value that is determined by the trial judge to be sufficient to be declared relevant. So not just sort of bare logical relevance, which is what seems to be what we have now. And the Law Reform Commission here has said it's just not a very workable standard. It's how do you know what's enough? It seems to leave too much discretion with the trial judge. The concept of legal relevance provides very little assistance. It's vague, and it sort of conflates two issues. which is the relevance of the evidence and the discretion to exclude evidence, as we'll talk about in a few weeks, that has low probative value. It kind of conflates those. It's not a very good rule. We're not gonna go with it. So what we seem to have now is a different rule than that, but let's see how it works. Let's see how it works in practice. One of the cases we'll look at is the High Court decision in Smith and McQueen. It's a case of a bank robbery. One of the facts at issue is the identity of the bank robber. The accused denies that it's him. However, there is CCTV footage from the robbery of a person who the Crown claims is the robber. In this case, there are two police officers who have some previous familiarity with Smith, but were not there. So this is kind of confusing because typically when you have witnesses in this nature, they're eyewitnesses, they're folks who were there. But in this case, these are folks who were not there, but have looked at these photographs or these printouts from the CCTV footage and say, "Oh yeah, that's Smith. We've had some previous experiences with this individual. Yeah, we're pretty convinced it's him." Just to draw that out, in case it's confusing, we have CCTV footage on the top there, and we have this man here in court, Smith. Here I've taken a screen cap from a show I like, Man in the High Castle. This guy's name is John Smith in the show. He's been the antagonist. And the police officers, again, who were not there, say it is the same person, just comparing Smith that we see in front of us and our conception of him that we have from dealing with him before, and these photographs, we think it's the same. I think it's the same person. So this contrasts with circumstances that you might be more familiar with, in which it's an eyewitness. So, hey, I was there. I was at the bank. I was walking by, or I was the security guard there, and I can tell you that the person I saw, based on my recollection, is this person Smith, who's here in court today, which is not the same as what's happening here. If it was just that sort of more standard situation, there really wouldn't be a question of relevance, I don't think, because you are someone who has some sort of experience that the jury does not have. You can tell them something about the identity of this robber that they don't know, because they weren't there. You were. I saw this person. This is what they look like. It was Smith. Instead, we're dealt with a more complex situation. So starting off, it's, I think, just useful to quote what the court in Smith says about the importance of identifying what are the facts in issue and how those relate to the evidence that's admissible to prove those facts in issue, and then how that ultimately leads to proof of some ultimate issue. This is exactly what we talked about in tutorial the first week, so it's useful to see some expression of that elsewhere. The majority in Smith says that this is not relevant, and they do because largely that distinction that I mentioned earlier. They say because the witness's assertion of identity was founded on material no different from the material that's available to the jury from its own observation, the witness's assertion that he recognized the appellant could not rationally affect the assessment of the question of identity that we have identified. There's just no contribution here. There's nothing new here. This is exactly what the jury can do on its own. Now here, I think you might usefully draw a distinction between a case like this when it's based on some non-eyewitnesses, so someone with not any, without any sort of direct personal experience with what happened, just some sort of lay opinion about the similarity between two sources of information, and a case of an expert. So someone who, let's say it's a fingerprint examiner who was not there, but is comparing something found there, like a fingerprint, and the fingerprint of the accused. This is a very different relevance issue, I think, because this person has some knowledge that the court doesn't have. They have some experience or knowledge that helps them make that comparison, even though they are looking at the exact same material that the jury has in front of them. A slightly different issue there. It causes us to approach the relevance question very differently. But in this case, the majority of the High Court seemed to say that, or they did say that, just having some prior lay familiarity with what a person looks like is not relevant. It does not assist the court in any way. There was a dissent in this case. Justice Kirby said, look, hey, listen, the uniform evidence law just says there has to be some rational connection between this evidence and a fact and issue. And the police officers had slightly more familiarity with this person than the jury does. They weren't in the exact same position. They had seen, the officers had seen this man before. And as a matter of logic, if you've seen someone before, you might be better equipped to pick them out of a photograph. However, he would find it admissible, but then excluded for one of the exclusionary rules that we'll talk about later. You might also think that there might be a risk of some sort of prejudice here. So two seeming authority figures are pointing the finger at somebody who have very little actual familiarity with somebody. That might cause some prejudice. You might see a jury just following the police officer's opinion in this case. But the reasoning didn't really get picked up in the judgments. The second of the two relevance cases that we'll talk about, final relevance case we'll talk about, is Evans. You might remember Evans from David's lecture last week. So in David's lecture, he discussed how having the accused dress up in the putative disguise worn by the robber and say something the robber said, that the issue there was if that constituted a view pursuant to Section 53 and therefore needed to follow the procedures therein. The court determined that it did not, because it was an in-court demonstration, not an out-of-court demonstration. But we'll talk today about the other issue of whether that demonstration was relevant to begin with. As the court said it was. So if you recall, there was some witness accounts and CCTV footage of somebody in a balaclava, sunglasses, and overalls, with at least one witness saying that the accused said something like, "Give me the serious money," with a particular sort of speech impediment or style, saying "Shirish," kind of the way Sean Connery says it, "Shirish." Come, Mr. Bond. So the issue was having him wear that and say that, walk around like that, relevant. The accused said, "Hey, this is Smith. This doesn't tell us anything more than what the jury can imagine by looking at the footage, looking at the balaclava, looking at the overalls. I suppose imagine him saying, "Shirius, this is not relevant. We've established this." There was also an argument that resonated with Justice Kirby, which was it's just also profoundly unfair to have the accused dress up like a robber and say, essentially, stick it up to the jury. So Justices Crennan and Hayden took this piece by piece and said, okay, first let's start with the balaclava. It might be the case that when he puts it on, he is going to look differently than the way he was described by the witnesses. So it seems like this has the potential to affect the issue of identity. So it's relevant. Also say that the pronunciation of Shirish is a distinctive way of saying it. If he says it that way, that sounds relevant to us, or it could be relevant. Furthermore, for similar reasons, seeing him walk around in overalls can help you understand if it looks baggy, as some witnesses said it did. This also helps us assess the fact of the issue, or has the capacity to. And they wouldn't exclude it under Section 137. Justices Gummo and Haim gave what, I mean, to me seems to be just a more incoherent judgment. They say that the clothes are irrelevant. Having him wear the balaclava, the overalls, that is irrelevant because this is something that the jury could imagine themselves. They can just picture him in their head with the balaclava and overalls on. I mean, fair enough, if that's what you think. My own experience, sometimes I'm looking at clothes and they look different than when I put them on. So that's just the way I kind of feel about that. But then they drew a distinction with the walking and talking and said, well, that's something that the jury can't imagine. So we actually needed to see him do that. I find this a tough distinction to draw. Justice Kirby says, paragraph 95, it's a broad ambit to what is relevant. It seems to be pretty clear based on the wording of Section 55. And then paragraph 101, we're looking at the capacity for this evidence to rationally affect the issue of identity. Relevant to that question was whether, and I'm just reading this, when dressed in overalls and a balaclava, when walking in front of a jury and when saying words ascribed to the offender, there were apparent similarities in the jury's view between the appearance and conduct of the appellant and earlier evidence. So seems to be a pretty clear logical connection here. However, he would have excluded it for being unfairly prejudicial, and we discussed it in week 1 a little bit, but evidence that isn't very probative but potentially unfairly prejudicial can be excluded, and this, in Justice Kirby's view, seemed to be a situation in which that should happen because while there is some probative value in this, it's pretty low, and in cases like this, there seems to be some serious prejudice that can occur. Just reading the last sentence of the last excerpted paragraph there, even if glanced at for a moment such an image, so seeing the guy in the balaclava saying, give me the serious money, give me the Shirish money, such an image, like images of hijackers, terrorists, murderers in films and documentaries, would etch an eidetic imprint on the jury's collective mind as an image unfairly prejudicial to the appellant. I find that logic compelling. So this is sort of the breakdown of the approaches. You might think to yourself, which one of these you prefer? I think overall, maybe this, for me, just drives home the fact that, if this really is a very wide ambit of evidence, and it's just, is there some logical connection between the evidence if accepted and fact and issue? Shouldn't be this there shouldn't be this much disagreement among members of the High Court, and it seems like some of them are just approaching this in a different way. It's almost like they're doing that kind of legal relevance or minimal probative value test that the Law Reform Commission rejected. In my view, it seems like Justice Kirby is hewing most closely to the rules it's written, but you can decide that for yourself. The final thing I'll say before I throw it to my good friend Salim is a bit of a rehash of what I mentioned earlier, and that's that another sort of key thing that can happen when establishing something's relevance is you will realize that it's relevant for an admissible purpose. And as I mentioned before, the clearest example of that is when you find it's relevant for only a hearsay use. I'll give you a quick example of how that could play out. So perhaps you have a witness that's going to say that he overheard that someone else, Bob, said that he, Bob, and the accused were in Bali on a certain night, and that was the night that the robbery occurred in Sydney. The relevance seems to establish that it could not have been Bob. Sorry, it could not have been the accused who did the robbery because he didn't have the opportunity. In other words, the relevance kind of depends on that being true about where Bob and the accused actually were that night. So it seems like the relevance here hinges on this being a true statement or not. And as Slim will discuss with you, that seems to draw hearsay scrutiny. But there might be other cases in which that isn't the only use of the evidence. So you can maybe imagine a situation in which the accused had previously said, or Bob had previously said, that they were not in Bali that night. Now we have a situation in which there's some sort of inconsistency. So the accused has said he was not in Bali, but another source says that he was. Perhaps there's another use for this evidence then, which is not dependent on where he actually was, but just the mere fact that he is saying inconsistent things. So the truth of him being in Bali or not would be not the issue there. It's just the inconsistency and perhaps his credibility. And as you'll see, there are rules for that, but these rules depend on the relevant use of the evidence. So to sum up, I think relevance is the fundamental admissibility rule. The test seems to be one of logical relevance and not legal relevance. The actual application might be more nuanced, and it sets the stage for other rules. I'll turn